This video walks through the life of a typical felony probation case from sentencing to revocation. In particular, it focuses on the new types of confinement created by the Justice Reinvestment Act and how jail credit for that confinement accrues over the life of a case. So suppose we have our hypothetical defendant convicted of a Class H felony and sentenced to 6 to 17 months, suspended, 36 months of supervised probation with a 30-day split sentence. What I want to do is kind of walk through the chronology of that case, and I want to focus in particular on the various kind of credits that the defendant will accrue through the life of that case. So we'll create this column over to the right here to keep track of those. And the first one that you'll come across would be pretrial confinement. And let's just say for our purposes that the person has 8 days of pretrial jail credit. The next thing that we would come to would be the split sentence. The judge ordered a 30-day split. This would be the first decision point for the judge to decide whether that 8 days of pretrial confinement will apply to the split or whether the judge would hold that time in the bank to be applied only in the event of revocation. And you can see that choice reflected in the judgment form. Got one waiting over here. On the suspended sentence judgment form, if you look at the jail credit portion, you can see here our defendant shall be given credit for 8 days of confinement prior to the judgment, and the judge gets to choose whether to apply that toward the suspended sentence, our 6 to 17 months, or toward the imprisonment required for special probation. So let's say the judge in our example decides to apply it toward the suspended sentence. The practical effect for the defendant then is that that split sentence is going to be for the full 30 days instead of for 22 if the 8 days had been applied. So 30-day split sentence. So the defendant does the 30-day split sentence, comes back out onto probation. Next, in the life of the case, let's assume there is a violation of probation. We'll call it violation number 1. And suppose the probation officer chooses to respond to that violation with a quick dip in the jail, as they're authorized to do. That's a period of 2 or 3 days in the jail. It can only be done with the defendant's consent, and so forth. Let's say that the probation officer chooses the 2-day option instead of the 3-day option, and so that's a 2-day term in the jail for that. The person does the 2 days, comes back out onto probation. Suppose there's later another violation. We'll call that violation number 2. This one, suppose it's more serious, so the probation officer arrests the probationer, and then he's held in pre-hearing confinement for 10 days, just for example, and then maybe makes bond. But when the violation hearing eventually comes around, suppose the judge imposes a period of confinement in response to violation, the CRV, in response to that technical violation. So we know the term of imprisonment for the CRV for a felony is 90 days, but how that time actually gets served has changed a little bit since Justice Reinvestment first happened in 2011. If we take a look down here at the relevant portion of the modification order that would be used to impose the CRV, we can see that the only proper term of the CRV would be 90 days for a felony probationer, that confinement will be in the custody of DAC. But where things get a little bit tricky is for the credit. So the defendant had 10 days of pre-hearing confinement for these days confined as a result of the violation. But what has changed is that before October 1st, 2014, the rule would have been that those 10 days must have been applied to the CRV so that the defendant would be left with 80 days left to serve in this case. What's changed now for violations occurring on or after October 1st, 2014 is that the CRV period may not be reduced by credit for time already served in the case. So of these 10 days that we awarded in line 3 there, the proper thing to do would be not to award any of them toward the service of the CRV itself. And so the practical result for our probationer, if we go back up to our little ledger here, is that the CRV period gets served for another full 90 days. So the person will go to Burke County or Robeson County to one of the CRV centers to serve that full 90 days, come back onto probation. Let's say they commit another violation at that point. We'll call it violation number 3. And suppose this is a more serious violation. The person is arrested for it, spends 10 days in jail awaiting the violation hearing, and then at the hearing itself, the result is revocation. So suppose it was a new crime or absconding. The question then becomes, what happens at that point of revocation? How much time is left to serve? Well, if we add up the time that the defendant has served already in the case, we can see that we have 8 days of pretrial plus the 30-day split is 38, plus the 2-day quick dip is 40, then 10 days of pre-hearing confinement the first time around brings us to 50, plus the 90-day dunk brings us to 140, then the final 10 days of pre-hearing confinement gives us a total of 150 days of jail credit in the case so far, which is equal to 5 months. And when the judge actually puts that credit on the revocation order, so this is a snippet from the Form 607, the order revoking the person's probation, they would put a minimum term of 6 to 17 months, our original sentence, in the custody of DAC for the revocation and shall be given credit for 150 days. So what does that mean for the defendant when you come into prison with a 6 to 17 month sentence that you've already served 150 days or 5 months of? Let me get this out of the way, and let's do what we've done in previous modules. Let's put our 6 to 17 month sentence on a timeline starting at 0 with our 6-month minimum and our 17-month maximum. We know that this last 9 months of the sentence from month 8 to 17 are going to be set aside and reserved for post-release supervision. Well, this defendant is already 5 months into the sentence based on the jail credit. And so even though this is styled as a revocation, what you can see is that at this point, the person will have somewhere between 1 and 3 months to serve before you get to the mandatory release onto post-release supervision for 9 months, with the final 9 months of imprisonment hanging over his head. In fact, you can imagine a situation where if the person had done maybe a longer term of pretrial confinement, or maybe one additional 90-day CRV, or possibly a 90-day term at Dart Cherry, when it came time to revocation, that person, if they had 90 extra days or 3 extra months, would have already been at the 8-month point at the point of revocation, and so even at the point of revocation would have immediately been released directly onto post-release supervision. So we've seen a fair amount of in and out of prison up to this point, but really we're just getting started because a similar framework applies to the defendant's time on post-release supervision. At this point, the person's released onto supervision for 9 months. Jurisdiction in the case shifts from the court system to the Post-Release Supervision and Parole Commission. And yes, if the person commits a new criminal offense or absconds during the term of post-release supervision, then the Parole Commission can fully activate these last 9 months of imprisonment. For technical violations, the most the Commission can do is a 3-month reimprisonment, so it's very similar to what a court can do for with a 90-day CRV. So for our defendant, if he were released onto post-release supervision and then committed technical violation of post-release supervision number 1, The Commission could respond to that with a 3-month period of reincarceration. That would eat up this first 3 months of the remaining 9 months of imprisonment, and then the Commission would have to re-release the person onto post-release supervision. Then if they committed a second violation, we'll call that technical violation number 2, the Commission could order another 3-month term of re-imprisonment, so that would take us further along in that remaining 9 months. And finally, if the person were then re-released and committed technical violation number 3 on PRS, the court could order that final 3 months of re-imprisonment. In reality, there probably won't be a full 3 months left because of whatever pre-hearing confinement there was in advance of the hearing before the Parole Commission. But nevertheless, at this point, the person will have served the full 17 months of imprisonment and will be released outright. So finally, to take a step back for a second, you can see that this is a very different process than what would have existed before justice reinvestment. First of all, for this Class H felony, there wouldn't have been any post-release supervision at all. There was no post-release supervision for Class F through I felons, and so this sentence for this defendant wouldn't have been 6 to 17, it would have been a 6 to 8 month sentence. Second, that the court would have had authority to revoke this person's probation for any violation, even as far back as the first violation here. That would have been a sufficient grounds for revocation. The person would have served 6 to 8 months and then been released outright. You can see that after justice reinvestment, with the limits on revocation authority and then with the post-release supervision to follow, it's a very different process from start to finish. I hope today's video is helpful. As always, please let me know if you have any questions or comments. Thanks.